Anthropology, Mrinalini Datta Mahabidyapith. I, Dr. Suchishmita Senchaudhuri, Assistant Professor in the Department of Anthropology. I welcome you all in this webinar on indigenous rights, issues, and challenges, organized by the Department of Anthropology in collaboration with Internal Quality Assurance Cell of our college, Mrinalini Datta Mahabidyapith, with wholehearted support from Honorable President of Governing Body, Srimati Chandrima Bhattacharya, and blessings from our Principal Sir Dr. Apurva Bandyopadhyay. Regarding the topic of today's webinar, I must point out that there are nearly 370 million indigenous people living in the world, having various connotations of the term at various parts of the world and various different countries. And thus, this issue is a very much global issue. And we are very much glad that we have two eminent scholars, Professor Hossain and Professor Castro among us to discuss the issue indigenous rights, challenges, issues and challenges. So I would like to share the platform to Dr. Suman Chakraborty for giving his welcome address now. Thank you. Over to Suman.
Thank you, Dr. Suchishmita Senchaudhuri. I think this day is very memorable for us, particularly the student of anthropology of our department, as because the dream came the true picture and true sense today. So at first, good afternoon to all of you, and from India, of course, as because the participants that are joining from the different parts of the world. So from that context, I'd like to tell them as good morning and also the good afternoon and good night too. So at the outset, I must wish all of you a very happy and prosperous New Year 2021. And now that our honorable president of our governing body of our institute, Srimati Chandrima Bhattacharya, our honorable principal sir, Dr. Apurva Kumar Bandyopadhyay, our IKC coordinator, Dr. Mithali Gangopadhyay, our colleagues from my institute, also the other institute, the student of anthropology and other subjects, and all. It is my pleasure to extend a cheerful and welcome to all of you. Your presence makes us very happy. I extend my special welcome to our eminent speaker today, Professor Kamrul Hossain from University of Lapland, Finland, and also Professor Nestor Castro from University of Philippines. They have agreed to join us and they will give us a complete picture regarding our today's webinar on indigenous issues and challenges based on the rights of their particular things. Now, before we introduce the main theme of our webinar, as I told you, the dream came true today because we have planned to organize this webinar before 1 year, I think. So we have discussed in our institutional meeting and also our departmental meeting. Now today we can establish that the indigenous issues is very, very important, not only in Indian context, but also the beyond India. As we know that indigenous is a term which is used differently in the different nations. And UN declarations in 2007, in 13 September, some of the countries, but most of the countries, signed the rights of the indigenous peoples. Apart from that, some of them, they abstain or they absent for that particular issues in order to give them much more protection to get the sustainable livelihood, life, and their survival. So the name indigenous is important for the global term, but indigenous, the recognitions of the people basically confined to the different countries and recognitions
ไม่
along
จะเข้า
with
ฟังลิมิติกละมันต้องเปิดจาก
along with the different kind of nomenclature. In India, we generally term the indigenous people as so-called the scheduled tribal people, and official record shows that there are near about more than 700 indigenous people, including the subgroups, who are distributed in the different parts of the India. Now the question arises that the conditions of the Indian scheduled tribal populations and their governance and their rights, we are very much aware of this fact. What kind of movement happened temporarily before colonization and post-colonization, we aware very much. We studied a lot of them. But now the question came, then what are the conditions of those people who are living in the other parts of the countries, as because out of these main indigenous group throughout the world, more than 30% of the groups, they are living in Southeast Asian countries. And also there's the unique features of the Arctic populations who are living in the northern globe and specifically in the Siberian regions. So that's why we invited two specialists who are extensively worked in Professor Kamrul Hossain in Arctic populations and Professor Nestor Castro, who work on the indigenous population of Southeast Asian countries. We are fortunate enough, we welcome a million times for their kind presence and for their deliberations in this particular webinar. So hopefully, again, I welcome to all of you, specifically the students and the participants and the viewers from the Facebook page, and also the different experts who are ready to keen to understand the indigenous rights issues and challenges. So at last, I welcome you all again, once again, for your kind presence. Sujishmita, thank you.
Thank you, Dr. Shuman Chakraborty. Now I would like to request Dr. Mitali Gangopadhyay, coordinator of IQAC as well as head of the Department of English of Mrinalini Datta Mahabidyapith. As I must say, she is one of the most important inspiration to us. I will request her to say a few words regarding the webinar. Over to Mitali.
Thank you so much to Sujishmita. It's a pleasure to be here. A very, very good afternoon and a warm welcome to all of you present on this platform today in this one-day international webinar, which is entitled Indigenous Rights, Issues and Challenges. This is organized by the Department of Anthropology in association with the Internal Quality Cell, Assurance Cell of our college, Mrinalini Datta Mahabidyapith. We are extremely delighted to have among us two eminent speakers today. Professor Dr. Kamrul Hossain, Research Professor and Director, NIEML, University of Lapland, Finland. We extend our warm welcome to you, sir, and look forward to hear from you the different aspects of global indigenous movements and how they lead in their own ways to achieve the right to self-determination. We are also happy to have with us Professor Dr. Nestor Castro, Department of Anthropology, University of Philippines, who will focus on the indigenous people of Southeast Asia and the challenges they face in regard to their rights. if I have to talk about the Department of Anthropology, I have to say that it is a department which is constantly engaged with a number of programs. And such programs not only focus on pedagogy, but also on generating social awareness through academics. The Department of Anthropology is, I would request everyone to kindly mute their audio. Thank you. As I was saying, that the Department of Anthropology is extremely vibrant because the department has industrious faculties who, leave no stones unturned to combine this theoretical teaching with practical fieldwork. What I exactly mean to say is that the department is not only teaching about indigenous people, in India or abroad, but the department takes every effort to take the students as much as practicable to these lands where they can meet the marginalized people and learn to see life from their perspective and learn much more about them than just reading about them in the books. At the end, I would like to wish a very happy new year to all of you, a corona-free year to all of you, and I hope this webinar ultimately turns out to be a grand success. Thank you so much.
Thank you. I thank you very much, Dr. Mitali Gangopadhyay. Mitali Di is always speaks some encouraging words towards anthropology department, and it encourages us to do something better for near future. Anyway, now we will start. I will request, before starting, I will request Ms. Tanushree Polle, one of the experienced teacher of our department, who is specialized in social cultural anthropology. I would like to request Tanushree to speak a few words regarding Dr. Kamrul Hossain before he begins. Tanushree.
Hello everyone, good afternoon and very happy new year to all of you. Welcome to today's session, and it's a one-day international seminar on indigenous rights, issues and challenges. I am Mr. Tanushree Polle, Faculty Department of Anthropology, Mrinalini Datta Mahabidyapith, and I have got the opportunity to introduce our first eminent speaker, that is Professor Dr. Kamrul Hossain, Research Professor and Director NIEML, that is Northern Institute of Environmental and Minority Law, Arctic Center, University of Lapland, Finland. And it's a great pleasure to me to introduce him. And he is also an adjunct professor at Public International Law at the University of Lapland. He is the leader of the University of Arctic Thematic Network on Arctic Law. Although by training, he has specialized in international law, and his research focus on currently lies in probably to international environmental law and human rights law, particularly concerning the rights of the indigenous peoples that applies to the Arctic. Over his academic career, Professor Hossain has extensively published in almost all areas of Arctic governance, such as in climatic change, our environmental protection, security and geopolitics, biodiversity, marine environment and the law of the sea, human rights and human security. It has been the principal investigator of a significant number of international and national research projects funded by the agencies such as the Academy of the Finland, the NORSPRO, the Nordic Council of Ministers of the Council of Baltic Sea States, etc. He has had several visiting positions in several renowned foreign universities, such as the Law School of Harbin University, such as the Law School of Harbin Institute of Technology in China, University of Technology, Sydney, and as a visiting scholar to the number of other institutes like University of Toronto, Canada, Hokkaido, and the Moran University of Technology, Japan. Thus, the Polar Research Institute of a number of Cambridge, the UK, etc. He served as special editor for several international scientific journals, including Yearbook of Polar Law, and regularly teaches at the University of Lapland and periodically at the other universities of other foreign universities of Europe and Asia. He received a number of prestigious awards, including SYLFF's Fellowship of University of Helsinki, Cone Foundation Postdoctorate Fellowship, Faculty Research Fellowship by the Canadian Department of Foreign Affairs and International Trade, DFA, IT, etc. Finally, now may I invite our eminent speaker, Professor Dr. Kamrul Hossain, to enlighten his topic and enrich us. And his topic is Global Indigenous Movement to Achieving a Right to Self-Determination. Welcome, sir.
Okay, thank you so much for the introduction, Tanushree. It was very kind of you. So let me share my screen before I start talking. Thank you so much for inviting me to this exciting event. I'm very grateful to Mrinalini Datta Mahabidyapith, and especially my sincere thanks to Professor Shumon Chakraborty, who has invited me to this seminar. And Shumon and I was friends for last several years, and we had the opportunity to meet each other in several occasions, including once in Mrinalini Datta Mahabidyapith. So it was a pleasure, and I'm honored to have this opportunity to speak in front of you on this important topic about Indigenous rights. And the title of this seminar, as you have already learned, is Indigenous Rights, Issues and Challenges. And my talk will be about global indigenous movement to achieving a right to self-determination. So what I would like to present in my talk, I would touch upon two issues. The first, how indigenous peoples' movement has reached in today's position and what was the process. So I will briefly talk about the process of indigenous peoples' movement and what were the aims of the movement. So one of the aims of the movement was to have recognition in international legal framework in order to achieve a right to self-determination. And in this context, I will talk also about a right to self-determination, what it is understood in present-day context. So my own argument about right to self-determination will be that we have enough of normative standards concerning right to self-determination, but I would suggest that now it is time to implement how we implement right to self-determination as it applies to indigenous people in all across the world. So before I start talking on these 2 points, let me first give you an introduction about who the indigenous people are. In the beginning, Shuchi has already mentioned that there are over 370 million indigenous people in all across the world. So these 370 million, also in some literature, it was suggested the number of indigenous people are almost 400 million in all across the world, but they are divided into 5,000 different groups, and they have around 4,000 different languages, and they are split into over 70 countries in all across the world. So the problem of indigenous people is that there is no clear legal definition of who the indigenous people are. So because of the lack of definition, it was complex when we talk about a right to self-determination that applies to indigenous people. To understand who the indigenous people are, there was a definition. It was given by, it is called actually COBO definition. COBO definition means that definition given by UN Special Rapporteur of the Subcommission on Prevention of Discrimination and Protection of Minorities. The special reporter, his name was Martinez Cobo, and he has given this working definition in order to put forward indigenous people's issues. In his famous study, the name of the study was The Problem of Discrimination Against Indigenous People. He sets out a number of criteria to understand indigenous people. So these criteria include, for example, historical continuity on their territory, before they were colonized. I mean, before the indigenous peoples were colonized by settlers. They are distinct groups of people, and they are identified by their own culture, own way of livelihood, own worldview, own cosmology, language, practice of religion. And in current context, they are not dominant social group on the land in which they live. But still, these groups of people are determined to preserve, to develop, and to transmit to future generation their ancestral territories, their culture, their ethnic identity. And they still exist as people in accordance with their own cultural patterns, social institutions, and legal system. And that is how we understand indigenous people in international context. But then again, there are different kind of connotation about indigenous peoples in national constitutions. So in this regard, I also would like to mention that indigenous peoples in all across the world are not known with the term indigenous people. In different countries, they are known by different terminologies. For example, in Australia, these groups of people are called Aboriginal. In North America, in Canada, and in USA, for example, they are called First Nations or Native Indians, etc. And in Indian subcontinent, as Professor Shumon has already mentioned, that they are called, in India especially, they are called scheduled tribes. And the country where I'm originally from, in Bangladesh, we called small ethnic tribal people. So there are different names when we refer to indigenous people, but commonly we understand them as indigenous people because their movement has started with this terminology, and United Nations has recognized them, all of them, as indigenous people. But then they have kind of common issues by which we recognize them. For example, in all across the world, these groups of people are subjected to similar kind of treatments. So their lands and resources were conquered, they were marginalized, they were assimilated, they suffered from historical injustices, and they have clear and concrete attachments to nature and nature-based livelihood. So they are the indigenous people. Now let me move to the struggle they have started for them to get recognition in international politics or in international legal framework. So these groups of people, indigenous peoples, were not organized in early 19th century because they have their own worldview, they have their own cosmology, they have their own knowledge system, they have their own ways of life. So they did not recognize the private ownership of land. So they don't have any ownership of land. They were having a huge territory on which they were moving. At some point, most of the indigenous people were nomadic in many of the countries. So therefore, they were enjoying the lands and resources of the lands. And they have, as I said, that clear connection to nature. But then when Eurocentric international legal development took place, their indigenous people's issues were not recognized, simply because there were no knowledge about the differences of systems in maintaining the ways of life. So therefore, indigenous peoples were not recognized. In early 19th century, there were a number of indigenous peoples leaders who realized that they have been gradually and increasingly marginalized and pushed in their own lands. And they started, by realizing these issues, they started kind of approaching to the existing international body. For example, in 1920, especially during 1920s and also in 1930s, these leaders of indigenous people, they moved to League of Nations, at that time the Club of States. and asked them to recognize them as distinct people, as having right to self-determination and not to be marginalized by the settlers. But their issues were not actually taken seriously at that point. And then, as I said, that indigenous people have their different knowledge system and different understanding of looking the world. They were not much formally organized. And because of their non-formal organization, they were not kind of recognized in international bodies where they could present themselves as having a strong entities. But when United Nations was created in 1945, again, these indigenous peoples leaders, they approached to the United Nations. And the purpose of creation of the United Nations was to maintain international peace and security. And it is a club again of the states, not of other entities. So states were the only actors in United Nations, and indigenous peoples' issues were lying within the states. So that's the intra-state matters, and United Nations was dealing with interstate relationship. Therefore, they didn't find any place to accommodate indigenous people within the framework of United Nations. Instead, United Nations asked these groups of people to negotiate with their national state to gain recognition in their national constitution and to achieve rights within the national legal system. And then indigenous leaders went back to their national government. So they were negotiating, consulting, and also appealing to the national government to address their issues. In some countries, or in some several occasions, some of the indigenous groups in some countries, they started armed rebellion against their own national government. But then there was a consensus among international lawyers that indigenous issues were part of the domestic issues, and they have to be dealt with within the nation state, because nation states were composed of the principle of sovereignty, which means that they have absolute rights, or states have absolute rights to deal with the issues that are within their own domestic territorial domain. And at some point it is said that, you know, this Westphalian concept of sovereignty that undermined indigenous people's issues, because the lands and territories that were occupied by the colonial power was on the name of terra nullius. The concept you can find in international law. Terra nullius means nobody's land, but in fact it was the lands, they were the lands of indigenous people. So nobody's land concept was included in international law to give the states the monopoly to force and to conquer indigenous people's lands. So as you can see that there were this non-inclusion within international legal framework to address indigenous people's issues. Then what happened? These indigenous people's leaders, they were, as I said, that very sporadically addressing their issues to international community, and they started realizing that they need to have formal organization. And by having formal organization, they will have a power to negotiate with existing structures within the context of, you know, international political society. Within international political society, they will have a place to negotiate, and in order to negotiate, they have to have their own organizations. So in 1956, the Sami Council was established as a non-governmental organization. And Sami Council was the organization of Sami people, and Sami are the indigenous people of Finland, Sweden, and Norway. And Sami also live in Russia's Kola Peninsula. So in 4 countries, this group of people are living, and they have gathered, and they have organized and they established their own organization, own institution called the Sami Council. And then in 1968, International Working Group for Indigenous Affairs was established. The idea was that to promote Indigenous people's rights, to clearly identify what are the common issues that lie for all Indigenous people in all across the world, so that you can start negotiating on the basis of those common elements. And then in 1974, World Council for Indigenous Peoples was established. And this council also invited Indigenous representations from all across the world to join the effort they take to promote or to kind of, put forward the rights of Indigenous people and to create an awareness about Indigenous people's rights so that world community can understand the differences, the distinction, and the justification for which Indigenous people claim their rights. In 1973, Arctic Peoples Conference was convened, and Arctic Indigenous peoples were in the forefront to promote Indigenous peoples' rights. And in this conference, the participants were from most of the Arctic countries, including from North American Arctic, Finno-Scandinavia, Russia, and also from Greenland. Then in 1977, there was a Pan-Arctic conference convened, and this conference resulted in establishing Inuit Circumpolar Council. And Inuit Circumpolar Council is an organization that today represents over 150,000 Inuit people living in 4 countries. And these 4 countries include Alaska, for example, from United States, Canada, Canadian North, and Russia, and also from Greenland. So this is how Indigenous people have established their transnational network. And through this transnational network, they gained kind of a political recognition to negotiate with the international community to promote their rights. And this way, they raised their issue to the United Nations. And United Nations, as I said, that at the early phase, did not recognize the rights of Indigenous people as distinct because those are the Indigenous people's issues were treated as issues, as domestic issues to be negotiated with the national government. But then because of the transnational networks and transnational organizations and because of the specific issues concerning Indigenous people's rights that were presented in many international forums, gradually Indigenous people's rights were recognized within the framework of United Nations system. And how? Here you see, in 1982, UN Working Group on Indigenous Peoples' Rights was established, and the idea of establishing this group was to identify specific rights that belong to Indigenous people. Why Indigenous people will have to be treated differently? Because they were also colonized at different point of time. So the main purpose of the working group was to prepare a declaration on the rights of Indigenous people. And that declaration was prepared and the draft declaration was finalized in 1994. But then this declaration at that time was not adopted, and it took 13 more years. As you have learned in the beginning from the introduction given by Professor Shumon, that in 2007, finally Indigenous peoples UN Declaration on the Rights of Indigenous People was adopted. And this was a huge success. So I will probably come back to this point later on. Here I just would like to give you some brief idea about how within United Nations system, Indigenous peoples' issues were addressed. So when this UN working group on the rights of indigenous people were there, and when draft declaration was adopted in 1994, and when the draft declaration was finalized and finally approved, finally signed in 2007, this working group was then replaced by another group which is called UN Export Mechanism, which is still continuing its function. UN Export Mechanism established in 2007, actually it is renamed of the UN Working Group on Indigenous People's Rights. And meanwhile, there was another organization created within the framework of United Nations. It's called United Nations Permanent Forum on Indigenous Issues. It was established in the year 2000. The idea of establishing this permanent forum was to raise indigenous people's voices in all UN systems. And along with this, an interagency support group was established, and UN Permanent Forum has had its first session in 2002, and it acts as an advisory body to the United Nations Economic and Social Council, in short, which is called ECOSOC. So there are three existing institutions within United Nations system. One is Export Mechanism, as I said. Other one is Indigenous Peoples Permanent Forum on Indigenous Issues. And the third one is UN Export Mechanism. Third one is Special Rapporteur. And Special Rapporteur on the rights of indigenous people, it was established by a decision taken in 2001, and it has a specific mandate concerning the implementation of the rights that are embodied within the UN Declaration on the Rights of Indigenous People. And it also do thematic studies on different issues on indigenous people, and acts as a coordinating body, and also identify the problems and implement the recommendation given by UN Permanent Forum on Indigenous People. So there are these three main institutions. And then one of the major events that took place actually in 2014, and it was by virtue of a resolution adopted by General Assembly in 2010 to discuss indigenous people's issues in a high-level plenary session of the General Assembly. It was called World Conference on Indigenous Peoples. And that conference presented the idea of best practice, how to implement indigenous people's rights as embodied in the UN Declaration on the Rights of Indigenous People. But then indigenous people's issues were also found within international legal framework, mainly within the human rights instruments. So there are these instruments, as you see from this slide: International Covenant on Civil and Political Rights, adopted in 1966. International Covenant on Economic, Social, and Cultural Rights, adopted in 1966. And International Convention on Elimination of All Form of Racial Discrimination, adopted again in 1996. But the problem was that all these three conventions, three human rights treaties, as I referred to, they did not clearly refer to indigenous people. However, some of the provisions of these treaties, they clearly are linked to indigenous people's rights. And later, the treaty monitoring bodies, which are the authoritative bodies and which have the role to, clear role to implement the provisions of the covenants, the provision of these, human rights treaties, they clearly addressed, or they clearly articulated that indigenous people's rights are rights to be covered within the framework of these treaties. For example, if we look at International Covenant on Civil and Political Rights, it has an article that gives minority protection, that is about minority protection, that gives protection to national minorities. Article 27 of the International Covenant on Civil and Political Rights clearly says that in those countries where minorities are living, they have specific rights concerning practice of their culture, religion, and language. And indigenous people in most of the countries are considered minorities. And therefore, this minority protection article is clearly linked to indigenous people. They have right to enjoy their culture, not only individually, but also in community with other members. And this has got reaffirmation when in 1994, within the covenant, the treaty monitoring body is called Human Rights Committee. Human Rights Committee has adopted General Comment 23. And General Comment means that the Human Rights Committee interpret how the article, how specific article is applicable. So when interpreting Article 27 in General Comment 23, Human Rights Committee clearly referred to indigenous people and clearly saying that indigenous people, their tradition, their culture that are composed of, for example, traditional activities, traditional practices in connection to their lands, hunting, fishing, gathering, and these kind of activities are part of cultures and thereby protected under Article 27 of the International Covenant on Civil and Political Rights. And same thing happened within the framework of International Covenant on Economic, Social, and Cultural Rights. Article 15, paragraph 1, which says that everybody has right to take part in cultural life, and states' duty is to protect and also to take affirmative action to promote the rights. It's not only to prevent the activities that affect the culture, it is also about to take effective measure to promote the rights. And that was confirmed by another authoritative statement, General Comment 21, given by the Committee on Economic, Social, and Cultural Rights, the treaty monitoring body, in 2009, clearly recognizing that indigenous people belong to this specific part and they are protected by Article 15, paragraph 1 of the covenant. And not only individually, but also to enjoy or to take part in cultural life in community with other members. So there you see that there are both individual dimensions and also collective dimensions when we talk about the indigenous people's rights within the framework of human rights treaties. Same goes with Convention on Elimination of Racial Discrimination. And there was a general recommendation adopted by the committee, the authoritative statement, committee meaning that, as I said, that they interpret, they give the clear interpretation how specific articles, how the provisions of the treaties could be, must be interpreted. So there it says that racial discrimination, all form of racial discrimination convention applies to indigenous people. But then only one international legal document so far is adopted what has the legal implication in international legal framework is called ILO Convention, International Labour Organization Convention 169, that directly address indigenous people. And that is the only legally binding convention in force that talks about indigenous people's rights in regard to participation in decision-making, consultation, and also remedy when there are injuries on indigenous people's lands and resources. But the problem about this convention is that even though it is a legally binding convention, this has a very, very poor ratification. So far, if I remember correct, only 23 countries ratified the convention, and most of the parties who ratified the convention, they are indigenous majority states, like in South American states, where Bolivia, Peru, that kind of countries. From the Arctic countries, it was only Norway who ratified the convention. Of course, Denmark ratified the convention, but in Denmark, there are no indigenous peoples. So Denmark rule Greenland, but Greenland has its self-rule government. So Greenland is the majority population of Greenland are indigenous Inuit people. Only 7,000 people are Danish origin native people. But in any case, so as I said, that there were only a small number of countries who ratified the convention. But then African Charter on Human and People's Rights is a human rights convention applicable to Africa, where they have also referred to indigenous people in some of their documents, some of their resolutions. But then in addition to human rights treaties, indigenous peoples' issues were also addressed in other legal framework. For example, in 1922, Rio Conference was convened. Probably you are aware of that. It was called UN Conference on Environment and Development. There, a declaration, Rio Declaration, was adopted, and in Rio Declaration, first time, it provided one principle, Principle 22. It clearly says about indigenous people's knowledge, their traditional knowledge and importance of traditional knowledge in regard to environmental management and biodiversity convention. And that was further even included in the Convention on Biological Diversity, and that was also adopted in 1992. There was a specific article, Article 8J, that talks about indigenous peoples, and of course, not only about indigenous people, but also about local peoples' knowledge and innovation. And then also it talks about the importance of those knowledge and to include those knowledge in biodiversity management. And also where their knowledge is used, they are entitled to receive benefit sharing from the use of biodiversity. So there you see that indigenous people's issues were recognized not only within the framework of human rights treaties, but also within the framework of other international legal developments. And then this has raised question whether when indigenous people have already gained this kind of recognition and their issues, their knowledge and their systems are recognized, and it was much more understandable in the current context how indigenous people's issues are relevant, then it was then the time came up to discuss about how indigenous people have how this recognition could lead to have a right to self-determination. But then self-determination has many different meanings, and there are different kind of claims when you talk about self-determination. It is a very contested term, but it is a norm that you can see in international law. Also, it is a norm, it is an international political principle in relation to territorial integrity, democracy, sovereignty, and so on. It has both internal dimension and external dimension. I will talk about that in a few minutes, about internal and external perspective of self-determination. So here I just would like to say that self-determination in general, it means that right of all peoples to freely determine their own destiny, to freely determine their own political status, and to freely pursue their economic, social, and cultural well-being. So in the document, in international legal documents, you will find self-determination attached to peoples. So that is confusing. Who are the people? That has not been clearly articulated nowhere. When self-determination itself was not interpreted clearly, how it should be, how it should apply, to whom it should apply. At the same time, who are the peoples? When it says people's right to self-determination, and this term peoples were not also clearly articulated nowhere in international legal instrument. So if you go to the UN Charter, the Charter of the United Nations, you will see the reference to right to self-determination in Article 1. and also in Article 55. In Article 1 says that the purpose of the United Nations is to develop friendly relations among nations based on respect for the principle of equal rights and self-determination of peoples. Similarly, in Article 55, it highlighted that the respect for the principle of equal rights and self-determination for observance of human rights and fundamental freedoms for all without distinction as to race, sex, language, and religion. Then in the UN Charter, as I said, that it says clearly the right applies to the people, but it did not interpret who these peoples are. There remains unclarity, there remains non-explanation, therefore it becomes a vague element. And it was very ambiguous as to argue that who are the entity to claim a right to self-determination and to what extent, meaning that what does it mean? Because when you look at Article 2, Paragraph 4 of the United Nations Charter, it is about protecting territorial integrity and political independence. In other words, sovereignty. So sovereignty is inviolable. It cannot be violated. So if sovereignty cannot be violated, and then when you talk about self-determination in the context of achieving statehood or independence, then it contradicts. So there are these complex issues, and how these complex issues will have to be dealt was not clear. But then in 1960, United Nations General Assembly adopted a resolution. It called Resolution 1514. And in Resolution 1514, it resulted in a declaration on the granting of independence to colonial countries and peoples, saying that a right to self-determination applies to colonial people who were colonized and who were colonized at different times in history. But then these colonial people will have to be understood differently, in a sense that they will have to have their own territorial border, internal and external border, can be clearly understood in a way that they are socially and politically subordinate. And there was a theory called salt water theory. It means that those colonies, they are far from the colonial power, can gain a right to self-determination, meaning that African countries who were colonized by Europeans are entitled to have a right to self-determination. And then what are the meanings of right to self-determination in this context? It is about independence. They have the right to claim independence, or they have the right to freely associate with other countries, or they can be integrated with their own colonial power. So these three elements were there when you ask for a right to self-determination within the context of United Nations, meaning that self-determination applies only to non-self-governing territories. So what was the position of indigenous peoples in this context? Because indigenous peoples were not geographically distinct. They don't have internal or external territorial borders to clearly identify their territories. So therefore, it is a complex to talk about a right to self-determination that applies to indigenous people. In other words, actually, if you use this model, then indigenous peoples are not entitled to exercise a right to self-determination, because that applies only to non-self-governing territories or trust territories. And this has got reaffirmation also in another UN resolution adopted by the General Assembly in 1970, which has resulted in a declaration, the Declaration on Principles of International Law concerning friendly relations and cooperation among states in accordance with the Charter of the United Nations, meaning that territorial integrity has to be protected, has to be respected, and indigenous peoples' territory, which is connected to the national territory, is kind of non-violable. Yeah. So which means that, indigenous people cannot claim the same right to self-determination as it applies to non-self-governing territory. Then what was it, the self-determination that applies to indigenous people? So we look at the UN Declaration on the Rights of Indigenous People, in particular Article 3, which says that indigenous peoples have the right to self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. This is actually the same article you find in two covenants: the covenants on international covenants on civil and political rights, and International Covenant on Economic, Social, and Cultural Rights. It is called Common Article 1. In both covenants, they use the same language. Only exception is that in those covenants, in Article 1, this is all peoples have the right to self-determination. And in Article 3 of the UN Declaration on the Rights of Indigenous People, it says indigenous peoples. But then there was a clarification given also in Article 4 that self-determination in this context mean autonomy or self-government in matters relating to their internal and local affairs. So that gives the indigenous people a right to exercise their self-determination internally, meaning that they have to gain some form of autonomy and self-governance from their own national government. And that was also because, as I said, that self-determination for indigenous people has to respect the territorial integrity. Otherwise, it goes against the provision of Article 2, Paragraph 4 of the United Nations Charter. And that there you get the reaffirmation also from the United Nations Declaration on the Rights of Indigenous People. In particular, Article 46, Paragraph 1, which says that nothing in this declaration may be interpreted as implying any activity or to perform any act contrary to the Charter of the United Nations. So when United Nations Charter's provisions are respected, it means that indigenous peoples do not have right to exercise self-determination as it understood in the context of giving independence to non-self-governing territories. They don't have right to choose whether they would like to have their own state, or they would like to associate with other states, or they integrate within their own national state. So that kind of self-determination does not apply to indigenous people. Then what kind of self-determination do we talk about when we refer to indigenous people? Well, most scholars talk about, they kind of differentiate external dimension of self-determination and internal dimension of self-determination. And in a very straightforward way, external dimension of self-determination refers to a right to claim, for example, statehood, to secede from the existing state. And internal meaning that indigenous people have autonomy or self-governance, or they negotiate with their own national government and receive autonomy on some of the matters to exercise their own matters by their own way without strong influence from the national government. In that way, internal self-determination is interpreted. So therefore, external right to self-determination does not apply to indigenous people. That was the mainstream idea. But I have some different opinion in this regard, because I try to reconceptualize a right to self-determination differently in present-day context. Before I talk about that, let me just tell you that why indigenous people would need to have the right to self-determination. As I said, that they have been also colonized at different times in history, but they have their own identity. They have their own established identity by virtue of having their own culture, own traditional way of life, own belief system, own knowledge system. So when there is an established identity, and at the same time, most indigenous peoples, they have their own institutions. So they control, for example, their traditional knowledge system. They control their, they have capacity to control their education system, their religious institutions, their customary norms, customary legal norms in their own way. So that gives them kind of agency. And when they have this established identity and this effective agency, then they could exercise a right to self-determination. And then I talk about right to self-determination from different perspectives. It does not necessarily have to be a right claiming for independence. It has to have some kind of procedural elements, because as I said in the beginning, that we have enough of standards, enough of norms. Now we need to see how these norms are translated into practice. And to translate them into practice, I would suggest that indigenous people have both internal and external right to self-determination. And how? So internally, as we said, that human rights norms give clear indication that indigenous people can exercise some of their rights in regard to, for example, in regard to matters that are of their own and that are of their own concerns. So any kind of activities within the land on which they live has to be given some kind of attention from the principles that we have developed so far. So one of those principles is called free, prior, and informed consent. In the United Nations Declaration on the rights of on the rights of indigenous people, at least in 5 places we will find the reference of free, prior, and informed consent. It means that any kind of developmental activities that are taken place on indigenous people's land has to be agreed upon with indigenous peoples themselves, with their own respective institutions. In ILO convention, as I referred to earlier, it was about consultation and participation. But then UN declaration clearly says that that's not enough. Consultation meaning that you consult with the indigenous people, and participation means that you invite them to decision-making process, but then you don't have informed consent, meaning that you have to understand the consequences and you have to consent. In other words, indigenous people do have a veto right. And that's how you exercise a right to self-determination in internal context. For example, within national legal system, you can integrate environmental impact assessment or human rights impact assessment or social license to operate. So these are the terminologies you use where you invite indigenous people to take part when it is about their matters, or when the activities or when the actions affect indigenous people's rights, and they have the clear clear right to participate in those kind of procedures. In that way, you exercise a right to self-determination, and you get confirmation of this kind of elements in human rights jurisprudence. At least there are 2 cases I can refer to in this context here. One is Saramacca people versus Suriname, a South American case where Inter-American Court of Human Rights clearly referred to Article 32 of UN Declaration on the Rights of Indigenous People, saying that even though UN Declaration was not binding, but within national legal system, national judicial system, they gave effect of the principles of UN Declaration on the Rights of Indigenous People, saying that there has to be free, prior, and informed consent before the activities take place with indigenous people, and indigenous people exercise right to self-determination this way. And also in Human Rights Committee is Angela Puma versus Peru case in 2009. In that case, Human Rights Committee clearly says that state was obliged to have free, prior, and informed consent of indigenous people. So you see how internally a right to self-determination can be exercised when it comes about the rights of indigenous people. Then how about the external dimension of exercising right to self-determination? Well, there are several examples I can just give you here. International legal process now include indigenous people as actors in many different ways. Of course, it's not kind of very clear-cut case, but in many different ways. For example, international climate change negotiation, international climate change lawmaking process that include indigenous people in the way that indigenous people can participate in the process through their own organization. So there is an organization called International Indigenous Peoples Forum on Climate Change. It's an Indigenous Peoples Caucus where indigenous people from different countries represent, and they raise their issue, and they also bring their own knowledge system that they have been using for thousands of years in regard to environmental management. And those knowledge systems have been having huge importance in lawmaking process, and that are recognized. So that is one way of having or exercising a right to self-determination in external context. Also, I refer to Article 8J. There was a working group composed of indigenous people as well to consider different elements of Article 8J of Biodiversity Convention. And since 2014, since 2014, there was United Nations Environmental Assembly that are being held in Nairobi in Kenya after every 2 years. So first one was in 2014, and then after I think the fourth one will be convened next year. So there also indigenous peoples, for indigenous peoples to recognize their knowledge system, there is an indigenous peoples focal point established. And this through this focal point, indigenous people participate in environmental lawmaking process or environmental decision-making process, or process that might lead to promote new norms to integrate in environmental law. So, and then there are other efforts. Since I belong to here in one of the Arctic countries, and I have been doing a lot of research on Arctic issues. So I would also refer here, the Arctic Council is an institution of the Arctic states, all 8 Arctic states. In most of these Arctic countries, you see indigenous peoples and their participation. So Arctic Council is an intergovernmental forum represented by 8 Arctic countries, but it has a special arrangement where, there are 6 indigenous peoples organizations from all across the Arctic. So they participate in the decision making. They sit with the state actor and participate in the decision-making process in international context. So by participating in this international process, they also exercise their right to self-determination because their issues were kind of clearly communicated with the states. And in fact, no decisions are taken without having approval from the indigenous peoples organizations. And in Finland, Sweden, and Norway, as I said, that there are some indigenous people living in these 3 countries. They have their own institutions called Sami parliaments. In each of these countries, they have Sami parliaments. So there are 3 Sami parliaments, and they also take part in lawmaking process. For example, Nordic Sami Convention is being adopted by these 3 countries. And when negotiation is taking place, there are equal number of representations from these Sami parliaments, along with foreign ministry representatives from the national actors. So it means that in this way also they perform a right to self-determination that is exercised externally. So all what I wanted to deliver here is that indigenous peoples do have right to self-determination both externally and internally, but you have to figure out how this right is exercised, and for what reason these rights are exercised. And these rights are exercised to promote democratic governance, both in national context as well as in international context. That being said, I thank you so much for your attention. Thank you.